In our last video, we discussed what to do when ICE comes to your door. Today, we're going to take it one step further. What happens after an arrest? What rights do you have? And what is the deportation process really like? The truth is that deportation does not happen overnight, despite what the media and the politicians want you to believe. In fact, you do have rights and legal options. So we are going to go over them right now and break them down. Most immigrants do have a right to a hearing before an immigration judge, which means you have an opportunity to fight your case before you get removed. But there are certain exceptions. For example, if a non-citizen is found within 100 miles of the border and less than 14 days after they have arrived, then they are subject to what is called expedited removal, and they are not entitled to go before an immigration judge unless they express a fear of returning to their home country due to persecution, and this fear is found to be credible. Additionally, a person who has a prior order of removal and are also found within the United States or at the border, they are also subject to expedited removal. That order can get reinstated unless they also express a fear of returning to their home country based on persecution, and this is found to be a reasonable fear. If you are detained and not subject to expedited removal, your case will go to immigration court. This court is very different from criminal court. It's based on administrative law. The rules of evidence are a lot more relaxed, and we are going to discuss how it works. Step number 1, you are going to receive what's called a notice to appear. A notice to appear is a document that you will receive whether you're in custody or out of custody, and this will tell you exactly why you are being detained or charged with removal, and it will tell you what your next court date is. Step number 2 is the master calendar hearing. This is a very brief hearing in front of an immigration judge in which the judge will notify you of what your rights are. For example, the right to be represented by an attorney at your own expense. And also you can tell the judge if you do want an attorney that you'd like to have more time, and you can ask for a continuance. Now, it's very important to note that if you don't appear at this initial hearing or any other hearing before the court, then the judge has the power to enter what's known as an in absentia order of removal, which means you can be ordered removed in your absence. Step number 3 is what is known as the master hearing or the merit hearing. Sorry, not the master, the individual hearing or the merit hearing. This is my favorite hearing. This is kind of where I feel at home as a criminal and immigration attorney, because it is basically a full court trial where you can present witnesses, you can present evidence, testimony, and you can argue why you have the right to stay in the United States under the immigration law. The government attorney in this case, which is OPLA, will argue against you, and in the end, the judge will make a decision about whether or not you are allowed to stay based on certain immigration relief or whether you must be removed. And if you must be removed, a final order removal will be issued. Step number 4 is appeals. If the judge does rule against you and there is a final order removal ordered, then you still have the right to appeal that order based on the law within 30 days. It's important to note that this appeal is going to be based upon the record that you already have. So you're pretty much stuck with this record. You can't add new evidence to it and new testimony. If ICE detains you, you might still be eligible for bond. Bond means that you or your family or a friend is paying a set amount to help you get released from custody. Now, there are certain people that are not eligible for bond. For example, somebody who's committed a very serious crime, and that particular crime in the immigration law is subject to mandatory detention. We also learned under the Lake and Riley Act that even committing a crime such as a theft or shoplifting can also subject you to mandatory detention, which means you're not eligible for bond. and even somebody who just entered the US unlawfully. They too are not eligible for a bond hearing. If you are eligible for a bond hearing, what happens? Well, the judge wants to find out whether you are a public safety risk or a flight risk. So it's very important to have an attorney represent you at this hearing to present evidence to prove that you are neither of those. Now, I'm sure that you have seen news footage of non-citizens being boarded on these military planes and deported altogether. Who are these non-citizens? Were they just arrested in raids, for example? No. These non-citizens already had final orders removal prior to the Trump administration, and they were waiting in custody to be removed. However, once the Trump administration came into power, new policies were in place that put pressure on these countries to accept their deportees. Also, what we are seeing is a lot of non-citizens who don't have final orders removal, but they're subject to mandatory detention. They're also being boarded on these military planes and sent to third countries such as El Salvador, Guantanamo Bay, Honduras, Costa Rica, and Panama. And these countries are agreeing to hold these non-citizens who don't necessarily have a final order removal while their cases are pending. Why are they doing this? Well, when a person is detained and fighting an immigration case, the case can take a matter of months, whereas where a person is not detained, their immigration case can take a matter of years. So the case will move a lot quicker, and that is the Trump administration's priority, to move these cases as quickly as possible so that non-citizens have a less likely chance to fight their case and to get relief from removal. So if you or a loved one is in fact detained by ICE, let's go over these key points to remember. Number one, you may very well have a right to a hearing before an immigration judge. Number two, if you are detained and given a notice to appear in immigration court, you may have a right to ask for a bond hearing to be released. And number three, do not sign any documents without first consulting immigration attorney, because one of those documents that you sign could very well waive your right to this hearing. If you enjoyed this YouTube video, please like it and subscribe, because I promise you I will be providing more immigration law, more updates, so that you can be informed and be empowered. Thank you so much.